the former president, is alleging Ramaphosa broke the law as an accessory after the fact, and that's in relation to Zuma's case against State Prosecutor Billy Downer and journalist Karyn Maughan. Let's make sense of all of this for you now. Bring in Professor Cathleen Powell, who's the head of public law at UCT, joining us via our video link this morning. Prof, great to see you again. Thanks very much indeed for helping us, I guess, decode some of the legalese around this case. And so much coming out of court in the past week. So let's hone in as a start on what Dalim Bofu essentially was arguing on behalf of President Cyril Ramaphosa, on behalf of former President Jacob Zuma. Major difference. Part of the argument being made is that they want to prosecute Cyril Ramaphosa not as the president, but as an ordinary citizen. Help us, I guess, as a start, make sense of what you took from that and whether, I guess, it's the right strategy.
Well, the only importance of that distinction right now is whether Cyril Ramaphosa has brought the application for an interdict in the right person, so to speak. So what happened was that former President Zuma, through his legal team, got a summons issued against Ramaphosa as an individual, and the interdict application is from the president of the RSA. And Zuma's legal team is trying to claim that that invalidates the application for an interdict completely, that the wrong person, in effect, is applying for the interdict, in that the president's applying and not the private citizen. I'm not sure what the court is going to do with that. It is a crime, if it was a crime, that President Ramaphosa could only have committed because he was president. So the court may find that that distinction is not important for the purposes of bringing the interdict.
Sure. For his part, Ramaphosa, as I mentioned, they're arguing that this entire process infringes on his own personal freedom, his dignity, and his reputation. How do you reckon that landed?
Well, I can't say how the court read it, but let us for a moment just stop and emphasize that there is such a thing as a private prosecution in South Africa. It's provided for by legislation. It's acknowledged in the CPA, the Criminal Procedure Act. So the mere existence of a private prosecution is not an infringement of those rights.
Right.
What would be the infringement is that the private prosecution hasn't been validly brought. Because there's a big difference between the state through the NPA prosecuting somebody and a private individual prosecuting somebody. There's certain very serious requirements that the private individual has to meet before he or she can start a private prosecution. And Ramaphosa's main point in this interdict application is those steps were not met. So that is what is infringing his rights, not the private prosecution in itself, but the fact that it was brought without getting a certificate from the NPA saying that it would not investigate, it would not prosecute this particular crime against Ramaphosa himself, as opposed to the original crime which Billy Downer and Karyn Maughan are supposed to have committed. The only certificate that we've seen from the NPA relates to the original crime that Ramaphosa is supposed to be an accessory to.
Sure.
But there's no certificate from the NPA to say we're not going to prosecute him for being an accessory after the fact. And that is the main point that I think the Zuma legal team have been skillfully trying to muddy for quite a long time.
Yeah, and perhaps some people might argue that's actually where the rubber hits the road, right? Whether or not the certificate applies essentially to this particular case. Do you envision a point
whether the Zuma team has in fact produced a certificate that the NPA will not prosecute the crime they want to prosecute?
Correct.
And they haven't.
Sure. Do you envision a scenario where the NPA will have to say something else? Because I think, if memory serves, a statement was released where it appeared that they tried to provide some kind of clarity. But here we are yet again. I wonder whether we should get to a stage where there's, I don't know, some kind of more unequivocal statement around whether or not they're unwilling, essentially, to prosecute this particular alleged crime with these particular individuals.
Well, look, I think that the NPA has been pretty clear so far, and that is why I'm referring with some irritation to the Zuma legal team's attempt to muddy the waters. Because what they've done is they've taken this statement by the NPA and taken it as another ground of grievance. What And in fact, there's no need or justification to do that. What the NPA was doing was simply saying, look, what we have released so far in terms of nolle prosequi, that's the certificate they have to produce, is that we're not going to prosecute anybody, in fact, for the crime supposedly committed on the 9th of August. Remember that in this case, the original crime to which Ramaphosa is supposedly an accessory is also a crime that the NPA has refused to prosecute. It's that weak in law that the NPA wouldn't take it on. And that is the claim that
Billy Downer leaked medical records,
leaked medical records. And the NPA clearly accepts the version of Billy Downer and Karyn Maughan on this one, that it wasn't a crime because she only released those records when they were on the public record because they were in the court records. So the NPA said, no, we're not going to prosecute that. Zuma's bringing a private prosecution about that one. And now he's trying to attach another private prosecution for accessory after the fact to the first private prosecution. The only certificates nolle prosequi he has relates to the first crime. And the NPA was trying to clarify that at the end of December. And the Zuma legal team have used that as an excuse to see yet more offense against their client, which there isn't. It's simply the point. The client has not got the certificate he needs to carry on against Ramaphosa.
That's really interesting. So if this case were to go ahead, it sounds to me that Zuma's legal team will first have to prove that a crime was committed in this particular case, and therefore Ramaphosa was an accessory to that crime. So it's almost these two hurdles still that need to be jumped over.
Yes, you have to prove two crimes. You have to prove that the initial one was committed, and then that President Ramaphosa tried to cover it up.
Right.
And, you know, what he did at the time was refer the Zuma's complaint to the right people, including in the NPA, and then left it. In fact, had he pushed further than that, he would have been violating the doctrine of separation of powers.
Right.
So Ramaphosa, even as an accessory, did nothing wrong. But the initial problem that Zuma and his team are going to face is that there wasn't an original crime either. And that also makes me wonder why they are in such a hurry to prosecute Ramaphosa for being an accessory, because the original private prosecution is still running.
Fascinating.
We don't know yet whether that was a crime.
Yeah. Let's do some scenario building very quickly if we can. Tomorrow the judgment is said to be delivered. We do know that there are two parts actually to this particular litigation. If Ramaphosa is granted this urgent interdict, what happens to Part B, essentially?
It still has to be heard. Part B is the substantive argument, and they've meandered into it a little bit in order to establish the requirements for Part A. But all Part A is about is cancel the summons, stop the summons, so that I don't have to go to court on the 19th. And the reason I don't want to go to court on the 19th and shouldn't have to go to court on the 19th is that the summons is invalid and was improperly issued. That argument then goes into Part B to be argued in full. That in effect, the private prosecution has not been validly brought because the certificate nolle prosequi was not provided. And in addition, there is no evidence that the Zuma side paid the deposit that a private prosecutor is supposed to pay. Basically, the Zuma side has not done the work you have to do before you bring a private prosecution.
So Part B, more about the merits of the case. Professor Cathleen Powell, always great speaking to you. Thanks so much indeed for helping us make sense of this. Professor Powell is the head of public law at UCT.